Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This podcast will be about 10 or 12 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Diego Beekman Mutual Housing Association versus Hammond, a very, very recent civil court case out of the Bronx. So let's set the stage with some context. Every residential apartment implicitly carries with it what's known as the warranty of habitability. That is so important in New York City, the warranty of habitability. It comes to us in a law called Real Property Law 235B. I put a link in the show notes to that in case you're curious. And what the warranty of habitability does is this. It's a law that says that every apartment, every residential apartment must be fit for human habitation. The apartment can never have any conditions which would be dangerous, hazardous, or detrimental to the occupant's life, health, or safety. And any agreement in a lease that says something different is void against public policy. So let's look at it this way. Let's say you're renting an apartment with no lease. It's just an oral agreement to rent the apartment. You still have the warranty of habitability. Let's say the lease is silent and doesn't say anything about the conditions that the apartment has to be in. You still have the warranty of habitability. Let's say your lease says something like, well, I'm the landlord and I'm going to let you rent this apartment, but I'm not saying that it's going to be in any good condition. It doesn't matter that those words are there. You still have the warranty of habitability. You still have a right for that apartment to be fit for human habitation. There cannot be any conditions that would be dangerous, hazardous, or detrimental to life, health, and safety. And with that, let's get into today's case. In today's case, the landlord sued the tenant for rent. And the tenant came into court, and one of her defenses was that she should not have to pay rent because she had a persistent and terrible roach problem. In fact, the tenant's attorney began their defense by making a motion asking the court to immediately issue a hazardous violation for roach infestation and to order the landlord to correct the violation by a date certain. The motion was supported by photographs depicting a very serious roach infestation, including roaches in the refrigerator. Oh my God. Ooh. The landlord opposed the motion, saying that the exterminator went in and, of course, blaming the tenant for the roach problem. So the court held a hearing to determine whether the alleged infestation existed. And this is what the court found. I'm going to do some reading. And that's why I chose this case, because I thought this judge in the Bronx did such a great job of not only explaining the law, but in this section of the case, he explains what proof he was looking for to come to his decision. And I think this is important for people to hear. So I'm reading from the judge's decision. Tenant's credible and unrefuted testimony was as follows. She has lived with a terrible roach problem for some time. Extermination, including vacuuming and spray poison, was done. The infestation remained. Tenant submitted several photographs and one video into evidence. Each was taken after the extermination services were provided. 4 photographs clearly show evidence of roaches. The video shows crawling roaches in a bedroom closet. In sum, tenant stated she sees roaches all the time and all throughout the apartment. Landlord has never investigated for roach nests or roach waste, has not sealed holes and cracks, and has not identified and stopped the source of moisture seeping into the apartment. No proof was offered that integrated pest management as required by the New York City Administrative Code was ever even partially attempted prior to the one time the landlord would end with an exterminator after this case began. Okay, that's the end of the quote. So the court found that the tenant proved a roach infestation in the apartment by a preponderance of the evidence. And I'm going to do a little one more sentence I'm going to read from the decision. The judge said, "Indeed, the condition can fairly be described as atrocious. The court finds respondent's statement that she lives in squalor truthful. As such, the court finds that the condition constitutes a Class C violation for roach infestation throughout the apartment, and Class C violations are immediately hazardous." So that's what the judge said in this case. So the court ordered the landlord to correct the violation within 21 days. Why 21 days? Because as the decision explains, the New York City Administrative Code for immediately hazardous infestation violations requires the landlord must correct within 21 days. And the court also ordered the tenant to provide access to the landlord on 24 hours notice. Now remember, this was a non-payment case. This tenant was being sued for rent. So will this result in the tenant not having to pay any rent at the end of the case? I don't know. I checked on the court file, on the online court file at the time that I'm recording this podcast, and there's no resolution of the case yet. The case is still ongoing. But it's a good example of how the lawyers in this case were able to change the hunter, that is the landlord seeking the rent from the tenant, into the hunted, meaning the landlord is being now ordered to correct within a certain amount of time. I did some quick research, and the most recent roach case that's published that I found was just a month before this case that I'm talking about now. It's called New York City Housing Authority versus Barrett, and I'm going to put a link to this case also in the show notes. And there, the landlord again sued the tenant for rent. The tenant interposed the Roaches' defense, and after a hearing, the court found that the tenant was living with egregious conditions, including roach, spider, and mice infestations throughout the apartment, including the bathroom and kitchen. And the court, this is a case in Queens, and the Queens court found that these infestations rendered the apartment uninhabitable, and the court granted the tenant a full rent abatement, meaning they didn't have to pay the rent that was being sued for. And more than that, the court in Queens ordered the temporary relocation of the tenant out of the apartment. The landlord had to pay for the tenant to be somewhere else so that the landlord could go in and abate these conditions, get rid of these infestations. Now, that's some pretty powerful stuff, but we have to consider it in the light of some important tenant takeaways. We really need to hear the takeaways here. Let's get the housekeeping out of the way first. This is not legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's awful, because really, I'm seriously asking you, please don't contact me. The pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to be answered on the air. If you like our work, please give us 5 stars and put this podcast on your socials. It's time for the tenant takeaway. Tenant takeaway time. If you only walk away from this podcast with one takeaway, I want it to be this: you have a right in New York City to a habitable and safe apartment. If there is a violation of the implied warranty of habitability, the landlord can be ordered to fix the problem, and it could result in you not having to pay some or all of your rent. But that's where I want to be careful and give a little bit more insight. So let's start here. If you need repairs, the best way to prove it and the lowest hanging fruit way to start the process of forcing your landlord to give repairs, if of course you ask for them, the place to start is to ask the landlord. And if the landlord doesn't fix it, then the next lowest hanging fruit place to go is dialing 311 or going online to 311, and you make a complaint with the city. And then be sure to grant access to the Department of Housing Preservation and Development inspector, who will be dispatched to your apartment so they can come in and write violations, which will be public records, against the apartment. And that is usually enough to force most landlords to fix those violations. But if that doesn't do it, then you have to escalate to another level. And there is a booklet, a free booklet, completely free on the podcast website about how to get repairs in your apartment. And it explores 2 or 3 options you have that are other than what we saw today, where tenants got sued and as a defense in the lawsuit said, well, I don't owe the rent because of the repairs. So you have other options. If you, for one thing, you have an option to sue the landlord in housing court. The tenant can take the landlord to housing court in what's called an HP proceeding. It's all there in the booklet, how to do it. And the court is very friendly with this. It's used to people coming in without lawyers. So you can take the landlord into court. And then if you are a rent stabilized tenant, you have the option of doing a special proceeding at the New York State Division of Housing and Community Renewal, the DHCR. And that is a whole other pathway. Okay, that sound meant we're going into our super tenant takeaway. Actually, that's not what it meant. What it meant was I'm working on a very primitive editing software and I had to cut the last segment and it sounded funny, so I put in this little 2-second thing. Anyway, here's the thing. If you need repairs and you're not getting the repairs, one thing I never recommend to tenants is I never recommend that they withhold rent and get themselves sued and then battle the issue out in a non-payment proceeding like the tenants we saw in the 2 cases today. Now, I don't know why those tenants didn't pay rent. Maybe they were desperate for repairs and they thought this was the best way to do it. Maybe they just didn't have the money. I don't know what was going on, but I do know one thing about both cases, both our main case in the Bronx and the case in Queens. Those tenants eventually had free legal services organizations come in and represent them. And these legal services attorneys are the best in the business. They know what they're doing. They know how to assert these defenses and they know how to prove them. In our main case in the Bronx, it was really brilliant what they did because they said, they did an order to show cause, an emergency motion early in the case, and they said, we are not going forward one more minute with this case until this tenant gets an order to correct this atrocious violation of roaches climbing all over her apartment. So, but if you haven't been sued, again, in the booklet I offer, or you can Google it, there are many ways to force your landlord to do the repairs. And getting sued does not come without controversy. Getting sued is stressful. It's time consuming. You'll have to take time off of work. It's for some people, and you don't know that you're going to get the result that these people got in the cases we showed today. And some people work in the financial industry and they check what kind of lawsuits are against you. And also, future landlords are not supposed to check housing court in New York to consider whether or not they're going to rent you an apartment, but how would you know if they did? So some people just want to stay away from being sued. And also for me, it always comes down to that hunter-hunted analogy. I think it's terrible that somebody should desperately need repairs and you need repairs. The landlord isn't doing what they're supposed to do, so you get sued. It just doesn't seem fair. To look at the other side of it, however, getting a judge to order a rent abatement to officially say that there's a portion of the rent that you don't owe, you're only going to get that if the landlord sues you in a non-payment proceeding and you fight it out like these tenants did. If you do the HP route I talked about where you sue the landlord will be forced to make the repairs. If they don't, the city will send somebody in to do it for them and charge it back to the landlord, and the landlord could be fined, but that money goes to the city, it doesn't go to you. And the DHCR route for rent stabilized tenants, your rent might be temporarily lowered a bit, but it's not going to deal with any outstanding arrears you have. You could make an out of court agreement with the landlord. Maybe the landlord will give you an abatement that you can come to terms on. The only way you're going to get it ordered really is to get sued. So if I leave you with I just didn't want to leave you with the impression that, oh, I have a terrible roach infestation, I'll stop paying the rent and I'll do what these people in these cases did. It's very important, great lessons we can pull from these cases. But I just want you to know that you don't have to get sued to get your repairs. So really, once again, if I only leave you with one thing, it's that no New Yorker should ever have to live with, you don't have to live with infestations of mice or spiders or roaches or whatever. You have a right to a infestation-free apartment, and there you have it. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.